Hello, this is Matt on the Moon Lambeau channel. Here's the latest headline from Finance Feeds. XRP lawsuit. Ripple's critical win is even bigger than imagined. So what's being discussed here? Well, unless you've been living in a cave for the last 24 hours or so, you may be aware that a major ruling came down yesterday. A court order from Judge Sarah Netburn on the reconsideration of the DPP ruling, the deliberative process privilege ruling. And the most important aspect to note is that this ruling, it basically reaffirmed the initial ruling, which came down January 13th of this year, in which the court ordered, Judge Netburn ordered, that the SEC must provide the 63 Hinman emails related to his Ethereum free pass speech, highly consequential. And Attorney John Deaton has been saying for some time that if it ends up being the case that the SEC absolutely must provide these documents, and it's beyond appeal at some point, if they absolutely must demand these documents, that there's going to be settlement within 90 days. Now, we're at a point where they could still appeal to Judge Torres. And they have 14 days to do so, but after that, once that's done, so maybe they appeal and Judge Torres gets back. Once that's done, assuming that Judge Torres upholds what Judge Netburn had to say, and that's highly likely, that at that point, that starts basically the 90-day timer from Attorney John Deaton's perspective for settlement. So it is that big of a deal. This is highly consequential. And so this article from Finance Feeds, it covers Attorney John Deaton's thoughts now that this has actually occurred. In a video where I was covering this topic yesterday, I shared his very initial thought. It was just like one tweet, but he ended up after that going way more in depth and providing a bunch of additional information that I think are all going to find very interesting. It's very positive, very good stuff. And you'll see as we go through this information that Judge Netburn, she really buttoned this up in such a way that the SEC, and we know that they're little baby back bitches, but the SEC, even if they try to whine about an unfair ruling, this or that, or it's unjust, or the judge did things wrong, blah, 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 according to Attorney John Deaton, they're going to have a hard time making such claims. But before going any further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. In we go. John Deaton, the attorney representing 65,000 XRP holders in the SEC versus Ripple lawsuit, has commented on the major ruling denying the SEC's motion for reconsideration, thus reaffirming the order to produce 68 documents related to the Hinman's 2018 speech. Now, while this order has been dubbed the biggest decision in the XRP lawsuit prior to the event, the court's ruling might be even bigger than predicted. And this is because of the bulletproof section Judge Netburn included in the court order that is expected to prevent the SEC to continue its delay tactics via an appeal to the Second Circuit. This could put an end to the SEC's delay tactics, which Ripple executives have complained about publicly and even called it gamesmanship in court, requesting the judge to apply sanctions on the plaintiff. Besides the lower probability of further delays, the order may trigger a settlement between both parties sooner rather than later. This is because many suspect the SEC will not produce its internal files, even if it costs it the whole case. So I'll just pause to note, and then I'm getting directly into John Deaton's comments. I'm of that mindset. It's speculation. But I do not think that the SEC is ever going to hand over these documents, even if they're ordered. I do think that they'd give up the case, they'd come to some sort of terms of settlement. They're never going to hand over these documents. That's my belief. I really could. And why do I say that? Because they're fighting so damned hard and so irrationally to prevent these documents from getting in the hands of Ripple. Now, the judge isn't having that, obviously, because it's unrational, unreasonable for them to claim privilege over these documents. And so that's why we've been speculating, like, what's in there? Is there one line anywhere in all of those emails that says something, okay, well, what about XRP? Because if that's it, as John Deaton says, that's game over. That's a term that John Deaton used, in fact, game over. If there's something in there that makes it obvious that even the SEC didn't know what the hell to do with XRP, it's done. Because how was Ripple supposed to know what they were doing wrong if the SEC didn't? I mean, that's why it is that big of a deal. This is bombshell news. So here's what Attorney John Deaton had to say. A few observations. Number one, I was wrong before when I said there were 52 drafts of the Hinman speech. The judge writes, Quote, as evidenced by the 68 drafts and associated commentary in the SEC's privilege logs, end quote. 68 drafts with lots of commentary. There's a strong chance XRP is mentioned. So I'll just pause to note, yes, with that much, when they're just if they're just talking about a speech, which again, of course, it's not official SEC position, it's just Billy Boy Hinman's personal opinion, and he's got his cronies at the SEC discussing it with him. You think XRP didn't come up once? One of the most well-known cryptocurrencies on the entire planet, one of the most liquid cryptocurrencies on the entire planet, been around longer than Ethereum. And it wasn't even mentioned. Like, it didn't enter the brains of any of these asshats at the SEC. Like, it didn't even enter their noggin. And then so as a result, it never ended up written down in email anywhere. Like, not once. Ah, man, that's kind of hard. That's kind of hard to believe. So again, it's speculation. We don't know for sure, but come on, look at how the SEC is behaving, right? So this is even better though. 52 drafts. No, 68. Yep, I'll take that. So even greater opportunity because there would be notes associated with all of these, presumably, right? Corrections, additions, blah, 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 evolution of the speech. Yeah, it just makes it that much more likely there's something in there that we'd like to see. John Deaton continues. Number 2, Judge Netburn added a bulletproof section for any appeal to the Second Circuit. She could have flat out denied the motion for reconsideration pursuant to Rule 6.3, and in parentheses he writes, can't raise new arguments you didn't the first time, into parentheses. Instead, she recognized how important the DPP doctrine is, deliberative process privilege doctrine. And this is good, so check this out. I'm going to show it to you. So he took a screenshot of his printed copy of this ruling from Judge Netburn with his little squiggles here indicating parts of interest and his notes. And here's what he underlined. Take a look at this. This is from Judge Netburn in the ruling yesterday. As these contentions were not put before the court on the underlying motion, strict application of Rule 6.3 would require denial of the motion for reconsideration. Nevertheless, the deliberative process privilege serves important public interests, and the court's analysis is guided accordingly. So that's the key part. See, there's a reason to even circled it right here for those of you looking at the screen. The DPP serves important public interests. The judge is acknowledging this, that the SEC can't come back and claim later, oh, come on. And you'll see why. So let me have John Deaton explain. Let me read a little bit further here. John Deaton wrote the following. She didn't just summarily deny the motion, but analyzed the SEC's substantive DPP argument and then rejected it. I love it. What she did was take away any argument on appeal based on how important DPP is, and that this judge didn't consider it like she should. Can you say brilliant? Exactly. So I mean, that's what I'm trying to say. Like, this is a very intelligent judge right here. I just, from what I've seen, this has just been my observation having covered this case for over a year now. This judge is very particular, and I'd say Judge Torres is too. But like there's a lot of strategy to all. So like that's why I've said too in the past, like even though we've all been annoyed by all of these delays, I've contemplated, like, is it possible that they're just, even though things don't look good for the SEC, obviously, is it possible that the judge is doing everything possible to make sure that the SEC is going to have less to come back and complain about if they want to appeal, which would make it less likely that they would get any traction on any sort of bitching and moaning grounds effectively? Because look, yeah, I didn't like the case being extended for like the 11 billion times that it happened. There's so many extensions, but the bright side might be that it's this type of effort on the part of Judge Netburn saying, okay, I'm going to make sure that these people can't come back and claim bogus stuff just to try and go over my head, because obviously if you're a judge, you don't want something that you rule on to be overturned in another court, right? And so she's being very particular with this, and I suspect that might have something to do with the reasons that there have been all these extensions as well. You see the same type of behavior from both Netburn and Torres. Anyway, John Deaton continues. Number 3, she called out the SEC for its inconsistent positions related to the speech. She said, you don't get to change your position just because you didn't like the court's conclusion. She highlighted the inconsistency by drawing specific attention to Hinman's under oath testimony. Number 4, she threw a bone to the SEC by clarifying the SEC could, quote, seek leave to redact those communications from its production, end quote. That implicates other separate agency deliberations, not deliberations about the content of the speech. Yeah, and I think that's the part I was going to bring up again. If this is the part that I'm thinking of. Yeah, I think this is these. Yeah. Okay. Yeah. So, for those of you that watched the video where I was talking about this yesterday, and you may have seen it elsewhere too if you're just on Twitter or other content creators on YouTube, but a couple attorneys within our community, and reasonably so, brought up concern about the opportunity for the SEC to come back in and redact stuff. I'm going to speak more on that. I spoke on it yesterday and I shared my opinion. I've got a little bit to add just to make sure it's crystal clear. Perfectly reasonable to bring up. I'm not concerned about it, and it seems as though John Deaton isn't really either. But I know attorney Jeremy Hogan did bring that up, so I'll talk about that more in just a second, especially for those of you that may have missed it. I'm not particularly worried. So again, let me reread what John Deaton wrote. He wrote, she threw a bone to the SEC by clarifying the SEC could seek leave to redact those communications from its production that implicates other separate agency deliberations, not deliberations about the content of the speech. So what's being stated there, just to be clear, is that the SEC can seek redactions for anything included in these 63 Hinman emails, including the 68 drafts. They can seek to do that, but only if it's specifically tied to ongoing deliberation that's parallel to this event here. So if it's just talk on this, the answer is no. The judge has already ruled. And so I've said many times, I'll just talk about it now so I don't have to come back to this. I'm telling you, this is just how I feel, and maybe I'm wrong, but this is what I'm thinking about it. I don't think that the vast majority of modifications and critiques to the speech as it went through the 68 drafts, it would be my hunch that very little, if any, comments had anything to do specifically with parallel deliberations. And if there aren't these parallel separate agency deliberations, and if any comment is not tied directly to that, then it's not going to get covered there. If it just comments about, well, okay, what about XRP? Well, that's an open comment that clearly, if someone just says something like that, it's not expressly tied to some sort of other deliberation. There would have to be some sort of indication in this that it is tied. And I just think the odds of that being in there, if any, and maybe there's something. In fact, actually, the judge did cite one example of what this SEC could seek to redact. My guess is it's not that big a deal, and Attorney John Deaton doesn't seem, from what I can tell anyway, to think that it's that big of a deal either. And then John continues. On one hand, this is good because it also makes this order bulletproof. Any appellate court will see that the judge is honoring all privileges under the law. There is no way, in my opinion, Judge Torres or the Second Circuit disturbs Judge Netburn's ruling. On the other hand, what exactly does separate agency deliberations mean? We would know what she means if we had access to comment 12 on page 6 of the speech draft in document J. Let me just pause. What's being cited there, comment 12 on page 6, document J, we don't have access to that. You may recall these documents have been reviewed in person, in camera, so that means in person, by Judge Netburn. We don't have access to it. Ripple doesn't have access to that, but she was citing that as an example. So technically we don't know for sure, which is why, again, I'm saying it's perfectly reasonable to speculation to think, okay, this is something that could cause things to go off the rails, and maybe. I acknowledge that is possible. What I'm saying, what I'm going back to is, how many of these comments could the SEC reasonably state? Because look, you'd have to look at the comment. It would have to be in the context of a separate deliberation. Like, think about that. The judge, I don't think she's just going to let anything, some wild claim be made that it's tied to some sort of other deliberation. Because look at how she's been smacking him down just here. That would be out of character for the judge. So if there is something that should be redacted, I suspect that it will be the right move if she allows the SEC to redact anything. It's probably a reasonable move. That would be my honest suspicion. I don't think she's going to let stuff that isn't tied to other deliberations, and very clearly, I don't think she's going to let the SEC just redact all that stuff. That would be my guess. So I get it. It's a reasonable concern. I'm just not that worried about it. And then John Deaton wrapped this up by stating, SEC is not allowed to redact agency staff communications about edits to the speech, and the edits themselves can't be redacted. The judge will review the proposed redactions. If XRP was referenced in the 68 drafts and or in the commentary, Ripple gets it and XRP wins. Golf clap for Mr. Deaton, everybody. Yes, indeed, and that's what I'm anticipating. I think John Deaton's hitting the freaking nail on the head here. There's going to be a settlement. That would be my best guess. It's not a certainty, so I got my fingers crossed a little bit here. But that would be my best guess at this point, seeing how hard they fought for this, because it's just going to destroy everything. Seriously, if this thing's fully adjudicated and if there's something in there that just ruins it, man, it's over. Although, I got to tell you, it doesn't make it that more ridiculous if it really is, if it really exists. It's that much more ridiculous that the SEC filed this in the first place. Were they not aware that this information exists? Like the people that were pushing this through? I don't know. Did they just not care? Were they just hoping, we're like, well, okay, we might not be able to win if this comes out, in which case they're just being terrible people. But, I mean, come on, they seem like terrible people to me. I don't know, folks. I'm feeling really good about this, though. I'm feeling at the best I've felt ever since this started. And for most of the last year, I've actually been feeling good. It's seen things develop, news come out, all that. This is big, though. This one's really big. We'll see. There's no guarantees. There could be a bad decision made, but I don't even think it's going to get to the point where we even see a summary judgment anyway. So I'm just like, okay, bring it. Let's see your move, SEC. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.